judiciary that provides either a system of impartial tribunals or likely to secure an impartial administration of justice. And that whole analysis needs to be conducted in practice. Another area where lack of judicial independence is relevant is the area of forum non-convenience. In the context of forum non-convenience, there are many factors that need to be analyzed for the court to determine whether the court that is considering the argument of forum non-convenience or the so-called alternate court is the one that should know the case, the one that is convenient. One of the factors within the forum non-convenience argument is the so-called adequacy factor. And what that means is that the court is supposed to determine whether the alternate court is adequate to know or to not know the case. The adequacy analysis also requires a systematic analysis of the judiciary in front of the judge. However, this standard differs from the one we saw before, referred to enforcement of foreign judgments, and it also differs among the different common law jurisdictions that have analyzed forum non-convenience. For example, in the Schwarzinger case in Canada, the court determined that the alternate forum had to be a forum where the case would be decided on the merits. That court concluded that Nicaragua, the supposed alternate forum for that purpose, according to the evidence presented, would not be a forum where the case was supposed to be decided on the merits. And accordingly, the court decided that Nicaragua was not an adequate alternate forum, and consequently, the Canadian court decided to keep the case for itself. As opposed to the Canadian standard for adequacy in the context of forum non-convenience, in the US, the paramount case has been Banco Latino versus Gomez Lopez. In that case, the US court established that the analysis for purposes of forum non-convenience was a lax one. And it determined that for the adequate forum to be analyzed, it did not need to be a perfect forum. And the court established that only corruption in that specific case will warrant the finding of the alternate forum being inadequate. Similarly, in the context of international investment law that has been discussed in detail and brightly by my good friend Judd Kessler, there are different references to lack of judicial independence that I want to discuss with you. I'm not going to get into the details of the arbitral awards that have been discussed before, but I want to make two references to standards that have been referred in specific treaties. And the first one that I want to mention is CAFTA. In the CAFTA agreement, there is a reference and an obligation for the states to provide investors with the so-called fair and equitable treatment. That standard of treatment includes an obligation by the state not to deny justice in accordance with the principles of due process of law. What that means is that if a specific state lacks judicial independence, then that state eventually would be denying justice to that investor and consequently would be violating the obligation portrayed under the specific treaty. That obligation, by the way, is also included in the new U.S. model bilateral investment treaty. Similarly, some bilateral investment treaties of the U.S., specifically the one between the U.S. and Ecuador, provide for an obligation to provide effective means of asserting claims and enforcing rights. What that means is that if a specific state lacks judicial independence in its judiciary, that specific state would not be complying with this obligation because it would be denying an effective mean of asserting claims and enforcing rights, and consequently that could give grounds for an international investment arbitration case against a specific state. In addition to those standards that I have referred to, there are other areas of law where the lack of judicial independence can be relevant. There are other types of transnational and international litigation, such as insurance policy claims. The one that comes to my mind is the example where a specific person has an insurance against indirect expropriation or direct expropriation or theft that comes under the form of disguised judgments or manipulated judgments coming from a judiciary that is not independent. Another area where lack of judicial independence is relevant is in the context of human rights. Specifically, countries have the obligation to provide due process of law to individuals. When they deny due process of law because the judiciary is not independent, they are exposed to international actions, either in the context of the European Court of Human Rights or the Inter-American Court and Commission of Human Rights or the United Nations Committee on Human Rights. Consequently, lack of judicial independence can expose countries for violating human rights if their judiciary is not independent. And lastly, the so-called futility argument. What that means is that eventually litigators, and for that matter the relevant parties, are needed to exhaust local remedies in specific cases. And eventually they submit the argument that it is futile to exhaust the local remedies because the local courts lack judicial independence. When that argument is presented, it is necessary eventually to support and to prove that the specific judicial system is one that lacks independence. Be it as it may, whether it's for purposes of enforcing a foreign judgment in the US or for purposes of foreign non-convenience and the so-called adequacy argument, or for purposes of international investment law in order to prove that the judicial system doesn't provide an effective means, bottom line is that in all those standards, what is needed is to conduct a systemic analysis of the judicial system. It's not an analysis of a specific case or an analysis of a specific court, but an analysis of the whole judicial system. So, then we turn to the third part of this presentation, and that is when we reach that level, for whatever purpose it is, then how do we determine that we are in the presence of a system that lacks judicial independence? In my experience as an expert witness, and also in my experience as a lawyer, what I have seen is that both judges analyzing judicial systems and also expert witnesses, they consider different matters, but what is important is that three conditions are key for this analysis to be successful. And those three conditions are specifically determined as per the delicate matter that entails the whole review of a foreign judicial system. It is a matter that touches the sovereignty of a country, and hence it's a matter that many countries are not willing to accept. For that matter, the three conditions that need to be present for an analysis to be successful are, first one, it needs to be an objective analysis. It needs to be unbiased. It needs to be supported on a specific documents and a specific data. The second condition is that